Welcome, everybody, to this month's episode of Regulation Central, presented by Polunsky Beitel Green. I'm your host, Robbie Chrisman. Very pleased to be joined by what's becoming our normal trio. We'll swap in Polunsky Beitel Green individuals as need be, but from Polunsky Beitel Green, Peter Idziak, uh, Brian Levy of Cat and Temple, and Matthew VanFossen of Absolute Home Mortgage. We have what should be a very substantive show, per usual, for all you. And before I get going too far, a big thank you to Polunsky Beitel Green for sponsoring today's show. I encourage all of you listening to this to check out mortgagelaw.com. They got some really great experts over there. But let's dive in, because I know that we never seem to be lacking on discussion topics here. I want to start kind of where we ended last month's show, and we opened a can of worms, talking about Director Chopra's recent comments, essentially saying that companies were going to hold you responsible for AI responses or interactions consumers may have with your artificial intelligence. And Matt, I want to go to you first here as the owner of an originator. You listening to Director Chopra make these comments, sure your mind goes, oh crap, I really need to buckle down and make sure I got things secure over on my end. But help us set the stage a little bit for where you think the CFPB is going when it comes to AI and how it monitors those interactions between companies and consumers.
Sure. Thanks, Robbie. So AI seems to be the recent buzzword over the past 12 to 18 months of the mortgage industry, and now seems to be the latest buzzword amongst our regulators, not only the lenders. And it's a very broad topic, AI, and how it's leveraged for originators. We've seen a lot of AI leverage on the back office as far as OCR, being able to decompile images, pay stubs, tax returns, and utilizing predictive response databases to go and kind of give you the sense of a virtual underwriter, right? But what Chopra was really talking about is consumer-facing AI, and that you have to be extremely careful when you start leveraging these things into consumer-facing, and most notably, anything relating to an AI chatbot or some new technology that we're seeing emerge, which is like automated AI predictive dialing, doing follow-ups with consumers. A consumer picks up the phone and it's AI, and they can ask it questions, and the questions have predictive responses, and it's hitting some type of a GPT. You can even ask it non-mortgage related questions. Well, where this starts to become very concerning is Chopra's commentary that more or less the active AI, when done under the guise of you as a company, is the same, that would be treated the same way as an active and individual originator or representative of your company. So if this AI is not properly trained, and most importantly, put guardrails around it, if you're deciding to leverage it based on how you can trip up this AI and what type of questions you can answer it and what its responses are, most notably responses relating to fair lending, any guardrails or around consumer protections, and incorrect responses it may give. So where I'm protecting my company is right now I've halted any type of AI usage or development that is consumer facing regarding any type of chatbots or any type of outbound calling to leverage that, because I just don't trust enough guardrails around it until we learn more about it.
Peter, I want to go to you next, and obviously this isn't a show that gives legal advice to people, but for you in conversations with clients that I assume you'll inevitably have on this subject, what are some of those discussions?
It's sort of what Matt talked about. It's that the real risk here is on anything that's consumer facing and interacts with the consumer, because you don't know for certain the answers it's going to give, and the predictive nature of the AI models. It will come up with answers that may contain wrong information, and so because it's not something that it has sort of like predefined hard-coded answers that it can sort of come up with its own, you need to be really cautious in deploying it in a consumer-facing environment. And then on the internal side as well, for those same sort of fair lending concerns, if your employees are using AI to assist them in their jobs, that they're aware of the limitations of it, and that it may provide incorrect information. It's sort of in the legal field, there was, whenever ChatGPT first came out, there were all these stories about lawyers who used it to write briefs, and it invented, realistic sounding quotes from fake legal cases. And if you're not in a position to know that, hey, like, I got to go verify this because it sounds, and that's the whole point of the model, it sounds reasonable, it sounds correct, it's confident. But until you know for certain, that it is, you got to be very cautious in using it.
Yeah, I remember that situation. I think the attorneys involved said that they asked ChatGPT, now, are these real cases? And ChatGPT said, oh yeah, those are totally real cases.
It is certain.
Okay. But it's interesting with Chopra's kind of approach and the whole CFPB's approach to AI. It's sort of this really difficult situation for the marketplace, because it's sort of preventing innovation from occurring and from efficiencies from being implemented, because they're demanding on the front end that the AI decisioning and uses be sort of proven to not have racially discriminatory impact or any other kind of discriminatory impact on the front end. It's not like you get a chance to use it and see how it turns out and then try and correct it later. It's sort of you have to prove that it's not going to have any effect at all. And I think that's just a bar that's greater than humans are capable of achieving in any event. And expecting AI to achieve it, I think is very unrealistic. And like I said, I think it's sort of preventing the market from experimenting.
Well, it's also a standard that they seem to be holding themselves to in some ways. When we're talking about like the appraisal algorithms and some of the systems that we've seen over the past couple of years, even our GSEs using when they're going through and doing post-closing examination and how different things are triggered for review. I do know that they're looking at it as well, and looking at how their own algorithms are looking at bias. So, the regulators looking at it, the lenders are looking at it. I think that the moral of the story is tread cautiously. You can quote Jeff Goldblum in Jurassic Park when he says, we sat there and we only focused on if we could do it, and we never thought, should we do it, right? And that's something that, all the companies that are out there and even the fintech providers, be careful how you're leveraging it. Be careful of how willing you are to incorporate it into your solution, because as you guys know, there's a lot of consumer disclosure in different states and federally that is required. If you are leveraging different components of AI and feeding any type of consumer data into that, there is also required disclosure as well.
I get the sense this overall Chopra administration has kind of been the administration of unintended consequences. I'm going to shift this discussion kind of forward to a next topic here, but there's a lot of talk about this name and shame registry that the CFPB came out with. Now they're telling you how to register, rather than people aren't out there asking, do you have the authority to even have this registry? And Brian, I want your thoughts on, before we get to where does this lead from here, kind of the audacity of the CFPB in saying, yep, name and shame registry, self-report, and we'll let the public shame you as a result, but it's incumbent upon you. Is that the proper way for me to look at it? Or
yeah, I think it's unfortunate. I think when Chopra came in, I had sort of high hopes for his view of the marketplace and how he, I think, had a philosophy around using greater access, greater market power for consumers, but in a competitive marketplace, and saw the role of consumer finance as an important one in America, and helping, certainly home ownership, mortgage lending, creating opportunities for achieving the American dream. And I thought that he was, sort of understood that while there needed to be guardrails around how things were done, that the lending industry was a necessary and important part of commerce, not something to be demonized, not something to be viewed as somehow nefarious. And I've been very disappointed in kind of his rhetoric and his approach. And I will say that on the enforcement side, I think he's done a pretty good job of going after the real bad actors instead of kind of like the stuff that Cordray was doing, which was going after the little guys who couldn't fight back, to try and, move the law in a different direction. I don't think I've seen too much of that on the enforcement side from him. And I have seen, quite a few, I think, bad actors called out. Now, this name and shame registry, I think that's just what it is. It's this opportunity to shame the lending industry, and while there's all kinds of questions about the authority to create that, I think the sort of the ethos behind it is what bothers me, and the demonizing of the lending industry, because I just think we don't want to have that kind of relationship with consumers. The consumer regulator should be trying to create efficient markets for finance, and not trying to make it seem like home ownership through mortgage lending is somehow you're dealing with bad actors. Everyone's a bad actor.
On that point, I actually kind of think this is a nothing burger, and let me tell you why. It's already existing. The NMLS Consumer Access Portal shows any type of consent order. It's been in place. CSBS has been overseeing it. If I get a consent order from a regulator, it gets posted. It's actually a good policing mechanism. I do anything possible to make sure that I'm acting in compliance, because my company's name is always at risk. And that is the fear that I have, is that I do get a consent order on the NMLS, and I want my company to maintain a clean record. Where I do think that it's overreach, though, is because we report these issues to NMLS, that, it's just kind of overreach, that we shouldn't have to go and report it to CFPB. If CFPB wants the data, go call the, CSBS and say, hey, we think that CSBS should be reporting this data out of the NMLS automatically over to the CFPB. And if the CFPB wants to leverage the CSBS APIs for NMLS to go grab that data and post it to their website, they probably have jurisdiction and a right to do so, because that's what they're there for, is to inform consumers, and inform consumers if somebody is on this violation list, or they do get these violations. As far as Chopra is concerned, he's definitely not Cordray, definitely not Kranger. There is a middle balance there, and the one thing I am, grateful for is it doesn't seem like independent mortgage bankers have been in his crosshairs or target as much as some of our other industry counterparts, such as, title. So, it looks like that it's the best of what we can get out of it, and we're going to see if we're going to stay with him, or we might have an administration change. We don't know. In the next 30 days, we'll see.
Yeah, just to follow on with that, I think, we all sit here within the mortgage industry, and, as Matt points out, like, this is sort of, something that's already out there in the public, but we've been sort of like caught up in this broader, regulatory push for this name and shame registry. And yeah, I mean, from our industry perspective, it's, more work on top of, what is already easily available to the Bureau if it wanted to work with state regulators to get it. And, the bigger problem I have is with the new attesting executive requirement, where you have an executive within your company that has to, swear and affirm that you were complying with the terms of the consent order. Because it's, I get that you want to hold someone, sort of personally responsible within a company to it, but what is, if it comes out later that, a company wasn't complying with it, what risk does that individual have? And, within your company, it sort of creates this, it's situation where the incentives and the responsibilities of the company might differ from one of your executives, and sort of can put you at odds with one another. That's probably the most worrisome aspect of it to me.
Accountability is key here, Pete, especially when you're talking about IMBs. The biggest accountability is that we're private capital. When you have an executive of an IMB and you're talking about holding them to the consent order, right? You're talking about that their house, their warehouse lines, all of this, their entire livelihood and their personal net worth is sustainably at risk. I agree on the state that the point that you made, that you could be creating some level of adverse relationships by the fact that they've already attested that they're going to abide to it by the state, and now you're making it federal as well. I just think it's a little bit of overreach.
Well, I want to keep extrapolating this a little forward. I get, and you mentioned how the title industry, a lot of this is germane to them rather than mortgage. And also in that same vein, I had asked the question originally, kind of like, who's going to stand up against the CFPB here? Who's going to fight? I know in DC right now, or there's this conflict of interest question, at least in DC, that, you know, affiliated businesses might bring in JVs. Someone else, it seems like someone would have to fight these attorney generals, but who's going to be the first? Brian, I'm obviously not doing a great job of explaining.
Yeah, well, I think you're confusing two different issues there, Robbie. One is the overreach by the CFPB in things like this name and shame registry, and frankly, I think that there is an opportunity to challenge them on their authority to do that. But your point is, well, who's going to do it? Who's going to, you know, is it such a big burden on companies to have to register and follow another regulation that, you know, just put it on my check kind of thing? You know, is it worth going to the mat on that issue? Or is there another issue that you'd rather lay down for? I think that's probably where the lending industry is, or at least the mortgage industry is on this point, because it's very expensive. And this is where we get into the other point, which has to do with the reasons why you settle in litigation. And in particular, what you raised was there's recently been some litigation settled. I don't even know if it was actually filed, but there was claims by the DC Attorney General against various title insurance joint ventures involving realtors that resulted in settlements with probably, I don't know, 3 or 4 different defendants in the millions of dollars. And the press release from the Attorney General was basically saying, you know, we've saved consumers, you know, millions of dollars, and these were, you know, illegal operations. And, you know, none of these were brought under RESPA. This was all brought under DC's version of unfair and deceptive laws and their title insurance regulations, which is interesting because their title insurance regulator literally had on their website how you could go about setting up an affiliated business arrangement that was compliant. So after doing that and conforming to the compliance obligations, the Attorney General comes back and says, we still think this is somehow a conflict of interest, this is unfair, and it's somehow increasing costs for consumers in a state or in a jurisdiction where apparently the title insurance costs were regulated so that everyone paid the same amount. So it's, you know, it was kind of a shakedown. That said, apparently Pennsylvania and Maryland are looking at the same thing. Now, from what I understand, Arizona looked at it and said, no, we're only concerned about ones that are really shams, that are not really complying with the RESPA obligations, which I think is a much better approach for a state regulator to look at it. But who's going to stand up? Well, you know, the costs of defending those kinds of an action can run in the millions, and you have no guarantee of winning. So, you know, as a business person, and of course, reputational issues, you know, all along the way. So what do? You know, everyone has to make their own decision. They have to assess their own case with their lawyers and ultimately decide whether settling makes more sense. I mean, you look at Townstone, for example. That's a fair lending case involving a single mortgage broker. You know, how does he have the wherewithal to go about fighting the CFPB all the way up to, well, now he's in the Seventh Circuit. His next step, he could go to the Supreme Court on one of the issues, or he goes back to the district court on others. But where does he get the wherewithal? Well, he doesn't have the wherewithal. The only reason that case is continuing is because the Pacific Legal Foundation, which is a conservative public interest law firm has taken up his case, particularly because of the First Amendment issues that it presents, and they are fronting the costs of that defense. So unless you've got that kind of support behind you, you have a business decision to make on any litigation, and I can't blame any particular defendant, for not taking it all the way to the Supreme Court, because that's their money. They have to decide what they want to do with it.
Peter, I can prompt you, but there's a lot there that Brian put on the table.
Sorry for filibustering again.
No, I mean, I think I don't have much to add because I agree with this point. It's sort of this collective action problem. There's, from the industry, we might say, yeah, everyone needs to stand up for them. But whenever it's, one litigation action against one lender, the cost of that lender can be enormous. And, I think that this case, predates Chopra, but it was sort of like the old CFPB, like, Townstone was always an odd case, but let's find someone small, get them to agree to a consent order that we then can publish. And then all the other compliance folks at all the other lenders, it gets on their radar, and you have to say, well, I think we need to be aware of this and try our best to comply with it. But, in this case, Townstone fought back, and at least the Seventh Circuit has won on one of them, on one of the issues, lost on another. And so you'll see what happens with it. But without the backing of private, these interest groups, I mean, I think that's why you've seen on the offensive, you've seen a lot of litigation against the CFPB that's filed by trade groups, because that way you can sort of get around these collective action problems. And also that way you can sort of, get your jurisdictional judges that you want. You can file them in Texas and get them heard by the Fifth Circuit. So, that's going to be, I mean, that really has been the same story for, years and years with the government. Is that if you're just one guy, one small company, whenever the government comes to you, we have these conversations all the time, I think I'm right. It's like, well, I think you're right too, but it's much cheaper just to settle and move on. Because you're in the business of making loans, you're not in the business of litigating against the government.
And that seems to be where we're headed with this, where it's trade groups need to take on some of these fights if there's ever going to be pushback, meaningful pushback. Peter, is that my takeaway from this a little bit?
Yeah, I mean, I'll let Brian talk, but yeah, I think that's where you definitely see, new regulations are put into place, and then you have the trade groups that are really taking the lead on this. And it's sort of in response to a lot of activity by the regulators, but I've been impressed by the the aggressiveness and assertiveness of challenging regulations and legislation.
Yeah, I mean, what I was going to say is the one example of an individual company sort of fighting the government that I can think of is when Dan Gilbert and Rocket Mortgage fought them on False Claims Act cases, and I think they ended up, going to the mat with them and probably settled for, pennies on what they were originally asking for. In my mind, that was a great pushback, but it takes a billionaire to be able to fight the government effectively. So I think it just proving the point.
All right, there you go. Well, I'll keep it moving here then, because I know, Peter, where you are in Texas, there's been an issue that's come up recently, and in general, I've heard a lot about the use of team names. I kind of want to get into the issues of when do I need to register a team name? Maybe it's handled differently between if you're a mortgage banker or a broker. When it comes to these team names or DBAs doing business as, what's the latest out there?
Well, so in Texas in February this year, the Texas Department of Savings and Mortgage Lending sort of issued some guidance that said that, if you use a team name, so if you're a group of loan originators or a branch and you want to be, like the Levy team or something like that, you can use that without registering it as a DBA, or in Texas they call it an assumed name, only in social media and advertising. But in any other line of business, like on the loan documents or in communications with borrowers or applicants, you cannot use the team name unless it's been registered as a DBA and added as a trade name in MLS. So there was I think initial thoughts from those within the Texas lending community. It's like, oh, great, so we can use team names without having to register them. But the more closely you look at it, the way they're actually used, although they will be used in social media and advertising, a lot of times it crosses over into business use as well. So if you have an email signature block that has your team name on it and you're communicating with applicants, well, the Department of Savings and Mortgage Lending says it has to be registered. So, the general advice that we've given to clients is that if you have team names, you should take the time to register them as DBAs, because, with a lot of issues with loan originators, you don't really know how it's going to be used. And you don't really want, the first time you're made aware of something is whenever the regulator comes back to you and says, hey, did you know that the team name, this unregistered team name was being used in this context?
So Peter, on that though, let's talk about compliance in usage. That's not feasible in some states. Like New Jersey is capped at 5 DBAs. Most companies have more than 5 teams. And the larger scale IMBs you get, you see large scale usage. Then you have some states like the Carolinas that require OTBs, which are the additional license per team, which is actually a separate call report that may need to be filed, a separate reporting that is, it's per license, right? And which would rack up. Now, cost shouldn't be an issue when it comes down to team. You have to factor that into your business controls, but that's a lot of work filing additional licenses. We know that teams can come on, teams can leave. I really support some of the legislation, or not legislation, the rulemaking that Texas is putting forward here, because it does put some guardrails on it. I'm under the assumption that team names should be DBAs, but with these other barriers across multiple states is the issue. I like what they did with marketing and advertising, because I don't think that team names are going to wind up on loan docs. Nobody's going and putting Team VanFossen in Encompass and needs it on a disclosure. We might have some big egos in the mortgage industry, but I don't think any of those are that big that it needs to be on the docs. But for email signatures, that's the one that's kind of like, okay, I get it. They need to make another little tweak. And if they could tweak where signatures, website representations, and put some guardrails around it, like things like the team name logo can't be bigger than the parent company logo, because some of this stuff has gotten out of control. And it looks like the team name is representing. And then you have states like New York that are very, very out there, okay, where if you're online doing a video and you mention your team name, we found certain violations and consent orders where they'll find the originator, not only the company in it, and the originator finds superseded. Whatever it is, I think Texas did a good job here at making the first jump, but we should be looking at other states and pointing this and saying, there needs to be some uniformity between multiple states and how these team names are being handled, because it is completely getting out of control. And it's no longer reserved for these $30-40 million origination groups. We're seeing, $2 million a month branches come out, or even single originators come out and start demanding their usage when they're going and being recruited from companies. So it's a challenging issue.
I'm going to add to go ahead, Peter.
Oh, just on one of your points, Matt, that was one thing that we've sort of struggled with, is if I'm a single originator, but I call myself a team, is that deceptive? I have an LOA, I'm part of a larger group. There's no good guidance on that, but with the team names themselves too, it's are they sort of accurate representations of
and you see creative workarounds. I saw somebody put an alternative legal name in for their MU4 as a team name and say, well, that's how I call myself, as an alternative legal name.
Interesting.
Yeah, so there's a lot of issues that are baked into this kind of whole team name concept. But fundamentally, these are state law issues. So, and it's not just a licensing question when you're talking about state law. So what does my regulator have to say about it? Can I have multiple DBAs? Is sort of the first question. And that's not always permissible in every state. But the second question is, well, who owns these rights to the name? And what happens if somebody leaves? And, what is the transition plan for the name rights?
Well, Brian, not to cut you off, but that's the DBA issue in itself, because in order to have a DBA, you have to file a foreign corp. It's not licensing, like you said, it's State Department of Corporations. And if you're
It
filing
may
a foreign
be,
corp,
it may not matter, you know, if it's somebody's name, somebody's last name, but if it's, uh, Volcano Mortgage or something, and that's what they want to operate the team name under, then you've got the DBA question. But I guess what I want to emphasize is, and particularly if you're a bank, a bank-owned mortgage company, and so maybe you're you aren't dealing with state licensing as much, but you still have to deal with the state regulator now operating in a different name. And so I guess the advice I want to give everybody is don't do this unless you've looked at state law very carefully in light of how you plan to market under that name. So you need to know the marketing plan, how is the name going to be used, and you need to know what does the state law say about that, and how does that impact your licensing situation in each one of those states. There is not a way to universalize this across the country and say, well, this is what we're going to do everywhere, because it's different. It's different in every state.
I'm going to keep things moving the second you guys pause. So I'll stay on the state to state issue here. And Peter, I know you've been following recent litigation in Colorado. And the issue is basically whether a loan is made in the location where the creditor creates and extends the loan, or where the borrower is located. And it's an interesting issue as states attempt to enact consumer protection statutes to protect the residents from lenders who operate out of state. You're the guy who's following this. I'm just a modest host here. Fill in the audience a little bit.
So this all arises under, well, I guess start at the beginning. There's a 1980 law called, and I have to read it because I never can remember, the Depository Institutions Deregulation and Monetary Control Act. And it's shortened to, so if you hear it called, it's DIDMCA. And DIDMCA allows state chartered banks to basically use the interest rate of the state in which they're located when they make loans in other states. But DIDMCA also contained a state opt-out that allowed states to opt out of that federal provision for loans, quote, made in that state. And there really hasn't been a lot that's gone on for years and years since this was passed, but recently several states have sort of looked, anew at opting out of these DIDMCA ceilings. So one such is Colorado, that they passed a law in 2023 that opted out of DIDMCA for consumer credit transactions made in Colorado. And the state officials there said, we're going to consider a loan made in Colorado if either the lender is located here or the borrower is located here. And that sort of goes against a long line of cases and in historic interpretations of DIDMCA that a loan is made where the lender was located. So the upshot here is that if I'm an out-of-state chartered bank and I want to lend to a Colorado resident, Colorado says I have to comply with their usury caps. Now, in the mortgage lending space, this could impact HELOC products. Colorado says this was really intended to combat payday lenders, but it really can, because it applies to consumer credit transactions generally, it can impact a lot of potential consumer loans. So several trade groups have filed a lawsuit against this, stating that Colorado doesn't have authority to opt out of loans made by lenders located outside the state to Colorado borrowers. So most recently, there's been a preliminary injunction that was granted by the judge hearing this in Colorado, who believed that the trade groups had a strong claim that DIDMCA would not allow Colorado to opt out of this. What's interesting, though, is that the FDIC actually filed a brief in support of Colorado that said that no, under DIDMCA, a loan can be made is considered made both in the state that the lender basically makes the loan determination origination and the state in which the borrower is located. And this is sort of, against what the FDIC has, the position they've long took. So, it's good news for lenders so far that the court has found that, this can apply to them. But there are several other states, like DC is considering DIDMCA opt-out, where this might come into play. So, one of the big policy arguments that the state chartered banks made was that, hey, federally chartered banks, have this opt out, and there's nothing Colorado can do about it. So you're just, putting us at a disadvantage. The judge didn't find that, helpful from a legal analysis, but I think as a policy standpoint, sort of made some sense.
This is really coming up in the context of, you never hear about usury laws, right? But every state has usury laws on their books, which limit the amount of interest that can be charged to a consumer. And every state's different, and there are some exemptions for first mortgage lending or purchase mortgage lending. But what's happening is interest rates were so low for such a long period of time that usury was never really on the table for anything. Now, as we see interest rates begin to rise back up again, some states have 8%, 10%, 12% usury limits. And if you get into some home equity lending, you may be subject to those kinds of things, and you may need to look at it. I don't know that we're totally there just yet, but it's something to keep your eye on for sure. And this Colorado case is interesting in that regard too.
Yeah, and Robbie, this was another one where you had the lawsuit was filed by several trade groups, so taking the offensive and kind of coordinating their actions against this regulation or statute, really.
And actually, Robbie, sorry to steal your job here, but this really is a good segue into the Citadel credit union.
That's where I was going to go next, Brian.
Then go there.
All right. Well, so what I was going to say is, this settlement, which has to do with redlining, was announced last Thursday, and it's the first DOJ redlining settlement with a credit union. That's the background that I would give before Brian. Why do you tie these two together?
Because I saw some data just recently that Citadel probably did, I don't know, less than 10% of their loans were purchase money, and 30-some% of their loans were home improvement, home equity, and 40% were, that like they not designated. But my guess is they were debt consolidation. So what you're really looking at here is a second mortgage lender showing up in the data, in the HMDA data, and that's very different, okay, than what has traditionally been the focus of fair lending regulators. This is sort of a new area, and I think part of their problem, frankly, is the lack of purchase money mortgages. Like, how are they going to reach new minority borrowers if they aren't helping, people buy new homes? So that's I think the insight that caught my eye on that particular consent order. And again, you can talk about consent order guidance, if you will, but it just gives you an idea that that's a new direction that the regulators are heading.
Peter?
Yeah, that's an interesting point, Brian, is that, part of so Citadel's located in like the Philadelphia metropolitan statistical area, and DOJ alleged that, I think like 21 out of 24 of their branches were located in sort of the outerlying counties that they were able to serve. But, you're right, from a mortgage lending standpoint, if you have a lot of people living in the city of Philadelphia, I think your renter versus owner makeup is going to be a lot different than it will be in the suburbs. So it's not necessarily surprising that your data shows that you're making more like home loans in those, outerlying suburban census tracts. But there were definitely some other issues that the DOJ raised, and as allegations, it was settled. So Citadel, of course, denied any admission of guilt. But I think one of the interesting things that sort of struck out to me was that in 2009, Citadel apparently represented to NCUA that they were going to expand by opening branches in the city of Philadelphia, and in exchange, NCUA allowed them to expand their membership community, and they never opened those branches. And the CEO at a board meeting then said, well, that wasn't a promise to do so. I guess it was, there's a difference between a representation and a promise. But again, this all, even though it's a credit union, even though it's new, the big issues are, from a compliance standpoint, analyze your HMDA data. The complaint says that as of, I think, 2016, Citadel knew that they lagged their peers in minority lending and didn't really do anything about that. So, that's one. And then they had a written fair lending policy, but they didn't do anything to make sure it was actually enforced, or any of their executives were trained on fair lending processes and procedures. So I think that's a common thread through all these consent orders. It's great that you have a policy, but do you actually follow it? And we, the regulators, have looked at your HMDA data. Have you? And if you see a potential problem, what did you do about it? Did you look deeper? Did you find maybe reasons that you are different from your peers? Do you have a story that you can explain to me? In this case, DOJ, whenever I come walking through your door, about why your numbers with minority borrowers aren't as good as your peer lenders.
And Peter, I'm trying to get the sense of, if a company identifies deficiencies, what is a satisfactory amount of acting upon that so that you won't get your door beaten down by the DOJ? It's a very blurred line, or how would you go about it as a company?
Well, I mean, I think, it's hard to give one specific answer to that, but I think, a lot of times where these stories start is either, consumer complaints and or an analysis of HMDA data. So you need to be analyzing your data, and you need to be looking at it as you compare to your peers. And if there are differences where you lag, you need to have an explanation for why that is. That hopefully isn't, well, we're discriminating. And if it turns out you are, then of course you need to make efforts to improve that. But if it's, well, our loan products makeup is different than these peers, like they're not really our peers. But you just, if a regulator walks through the door, you need an explanation for them. Now, whether they're satisfied with it or not, that's impossible to say. But, if it's, oh yeah, our numbers are lower, but, we don't know why. We're just going to try and improve it. Well, what did you actually do to improve it? Well, not much. That's not a good response. And it's sort of surprising how often these consent orders come out, and it's basically, they, at least from the DOJ's point, or CFPB, well, nothing was really done about it.
Brian, you have thoughts on what a proper amount of remedy work is to satiate some of these larger government entities?
I think you have to be true to your fair lending narrative. If your business strategy is to focus on the Hispanic community, your numbers might not be great in the white and black community, in relative to your peers. But if that is your strategy, I think that's a strategy that you can justify and explain. But if your strategy is, well, we just want to get every loan we can, and you aren't, kind of matching up your demographic success to the racial demographics of your community, you're going to have a tougher time of explaining why you don't have that. So I totally agree with Peter. You've got to look at your HMDA data, but you also have to know what your business strategy is and how that will potentially impact the makeup of your customer base.
I think what I'm trying to get at, and this is probably a good place for us to kind of end the discussion today.
I don't get commentary on this at all.
You're over there,
Just because I'm an IMB, I'm excluded.
You're over there working on your chatbot, but you can answer. You can take what I'm about to say and answer it, or you can say what you're going to say, and that is, in general, the sense we get of these government agencies are out to do us wrong versus they'll work with us versus they'll kind of give us a warning. Like, what is the interplay between originators and regulators when it comes to doing what's best for the consumer, being given an opportunity to remedy these things? Or Matt, just say whatever the heck you want to say.
Well, regulators are not here to put us out of business. I don't think that's their case. They're here to regulate, to come in, to look at checks and balances and make sure that we are operating via their oversight and their regulatory code. If they put us out of business, then there's nobody else to come back and maybe find us next time. So I don't think it's their initiative. They're making sure that we're on track and doing things the right way. Now, when it comes to stuff like Citadel, and if you go look and unwind what their remedies were between the $6 million subsidiary fund, the $250,000 in community partnership, the $270,000 in advertising, the hiring of the community lending officer, all of this stuff could have been done before it got to this point. And that's where, whether you're a bank, a credit union, or even an IMB, because even IMBs are on the threshold of CRA implementation in many states. And if you go unwind CRA, it has a lot of fair lending tied to it, and a lot of things that come down to something very simple. Offense sometimes is the best defense, meaning that you can go on the offensive here. You can go and look at your geographic targets, what states you lend in. It's very easy to identify low to moderate income areas, underserved areas, and having proactive outreach. What does proactive outreach mean? Billboards, advertising, newspaper, radio, social media campaigns that are geo-targeted to promote home ownership to underserved communities. And it's not just about advertising. It's also about what are you doing to engage in that community? What are you doing to make sure that your marketing service agreements with real estate agents are not only in areas that are not inside those areas? Go and target real estate agents in those communities. Go to the community centers, go to the churches, the religious organizations, do events and create logs and records of this stuff. And maybe you don't have the budget for a community lending officer, but you can have somebody in a dual role that gets this responsibility and oversight for it. So when the regulator comes in, a lot of this, if your data doesn't match up, they know that you can't make loans just appear out of thin air. But your fallback for not having the data add up is, well, what are you doing to fix it? If the answer, like Peter said earlier, is nothing, now you got yourself in trouble. But if the answer is, hey, we noticed this, and let me show you our plan. Let us show you what we're doing now. Let us show you what our 6-month rollout plan is. And as if you have an answer, Robbie, now it's better than kind of just be saying, I don't know, and shrugging your shoulders, because it shows that you're making a proactive plan, no matter what size you are, from a small mortgage broker all the way up to a large bank. You need a plan and you need a strategy.
Matt, I only have questions and no answers, but I appreciate you having the answers for us. And, I love giving you the last word on all my shows here. So thank you for that. Big thank you to Peter and Brian as well. Always enjoy the discussion. And also a big thank you to Polunsky Beitel for sponsoring today's show. We will see everybody next month after the election. Raise your hand if you think Trump's going to win. No, don't. All right. We'll see everybody next month. Thanks a lot, guys. Appreciate it.
Thanks, Robbie.
All right. Thanks, Robbie.